Hey guys, welcome back. Today's case is one I honestly thought had disappeared, but it finally wrapped up and the ending did not disappoint. Not because of some dramatic twist, but because the judge's reactions to this sovereign citizen's completely bizarre logic are on another level. The responses, the tension, the sheer confusion, it all builds up to a conclusion that's way more satisfying than I ever expected. Trust me, you're going to want to see how this one ends.
We are on the record calling 2-1-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. No appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right, Mr.
So we attempted to do discovery anyways.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
And seriously, what does freeze even mean? What kind of logic is that? Because the only way it makes sense is if you genuinely believe that scribbling on the outside of your discovery packet somehow cancels it out. Writing "I don't accept this" in bright marker doesn't erase anything, it just highlights how deep you are in denial. At that point, you're not fixing the problem, you're putting it on display.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or not.
And what exactly did you think was in that packet you refused? Because turning down your own discovery might be one of the worst decisions you could make. All it does is ensure you walk into court completely blind, no understanding of the allegations, no awareness of the evidence against you, nothing. At that point, you're not defending yourself, you're stepping into a legal fight without even knowing what's being used against you.
They just coming with these allegations. I'm trying to see and verify if it is. Then when they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already,
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
You, Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
Talking.
This is not a clown show.
Oh my goodness.
One at a time.
I can finish my statement.
You will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr. Hurst.
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute you.
I don't even understand what's going on.
Well, that part I don't doubt for a second. Honestly, based on everything we've seen so far, your decision making speaks for itself and not in a good way. You consistently manage to turn simple situations into unnecessary chaos and somehow make things worse every step of the way. At this point, it's not even surprising anymore. It's just a pattern. And watching it play out in a courtroom setting makes it all the more unbelievable.
I'm muting Mr. Hurst, and I will let Ms. Strickhardt say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickhardt, you are responding to Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refuse the packet, because I don't know if they're trying to contract with me or not.
Trust me on this. Sovereign citizen thinking is basically a financial black hole. It doesn't just drain money. It pulls in bad decisions, confusion, and every dollar within reach. No one with even basic financial sense is going to willingly contract with you. In reality, most people would distance themselves the moment they see where it's headed, because once you buy into that mindset, the consequences tend to spiral fast.
I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you, then so be it.
Sounds like a fair deal to me. If you're set on sabotaging your own situation, no one's going to stop you, but don't expect the court to step in and fix it either. At a certain point, the responsibility is entirely yours. And trust me, by the time this plays out, even Judge Robinson won't be taking it seriously. You'll have turned the entire situation into something that's hard for anyone in the courtroom to ignore.
I got a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you, I got a question. Should they have sent me something before they send me this package since the last court date?
Sir,
to verify that?
Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case. The same way
so she's going to send me a packet, and I'm going to send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the
Don't interrupt me again. We had this conversation before, didn't we?
Sorry.
We had this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatories, request for production of documents, and request for admissions. Same as her.
Well, he's in the same position as her, just without the years of legal training that might have helped him defend himself even halfway effectively. And that difference really shows, after all the resistance and posturing, he finally gave in and accepted the packet, bringing his first appearance to a close. But that's only the beginning, because when we move into his second appearance, things take an even more interesting turn. Trust me, it only gets better from here.
All right, we are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter, knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without prejudice.
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right. Where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking
you
first if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan court rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other side.
He's about to get a full serving of reality, and not the kind you can ignore. Every bad decision up to this point is about to catch up with him all at once. And now we finally reached the moment I've been hinting at this entire time. When I say it gets fun, I don't mean for him, I mean for the judge, because what unfolds next feels less like a typical hearing and more like something you couldn't script if you tried.
All right, the court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate, with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank. Plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have in our request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the court rule, is not supported by an affidavit. 2.116G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must, by affidavit or as otherwise provided in this rule, demonstrate the existence of genuine issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the 3rd page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So the defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate it.
And it only gets bigger from here. This is one of those rare courtroom gems that somehow gets more entertaining every single time you watch it, with each moment hitting harder than the last.
And
If he has 6 kids.
No, let's Ms. Garcia.
yeah, that you supposedly love.
That you
Oh,
leave
You'll
Thank
have
you.
a
home
chance
to
to,
come
Please.
across.
Ms.
I
McNabb
do
will have
not.
a chance to question.
Don't go there with my kids, please.
This matter comes before the court for a hearing concerning an alleged violation of the court's protective order. Ms. McNabb, would you place your appearance on the record, please?
Thank you, Your Honor. Lauren McNabb, Assistant Prosecuting Attorney, Kent County, for Petitioner Ms. Garcia.
Very good. And I do see Ms. Puerto present. Ms. Puerto, did you employ counsel for the purpose of today's hearing, or are you representing yourself?
I am representing myself.
Very well. Thank you. You may proceed, Ms. McNabb.
Thank you, Your Honor. I'd like to call Ms. Garcia as a witness.
Very well. Ms. Garcia, would you raise your right hand?
Thank you, Your Honor. You are Lizette Garcia,
Correct.
and you are the petitioner in this matter?
Correct.
And Your Honor, I would just ask that the court take judicial notice of the dates that this PPO was in place. It was granted from February 15th of 2024 until it was terminated on September 9th of 2024.
Okay, very well. I will take judicial notice of those dates.
Right, thank you. So, Ms. Garcia, you have a PPO against Ms. Puerto, correct?
I had one placed, correct.
Okay. Did you attend the hearing where that was terminated?
No, I did not attend the hearing where that was terminated because I had it sent to a different address, so Miss Puerto couldn't find my address.
Okay. So it was terminated because you did not appear.
Correct.
Okay, thank you. And so you filed a motion to show cause alleging violations of the PPO.
Correct.
Has Ms. Puerto made any direct contact with you or contact through third parties?
Third parties was the violation.
Okay, and explain how that happened.
After I placed the PPO onto Angie Puerto, I'm assuming it didn't settle with her, so she continued to make phone calls unwantedly. Her and my child's father, have zero connection, zero contact. The reason why Angie Puerto got the number to my child's father is because I called him in the past from her phone. She continued to contact him to the point where my son was even involved. And Nate made a statement stating that if she were to contact anymore, he was going to block her and also help me further gain a PPO.
Okay. How did you know it was her calling?
Now moving forward, this is where things begin to take shape. The petitioner lays out her claims, explaining how the protective order was allegedly violated through third-party contact. She introduces repeated calls to the child's father, painting a picture of persistent interference. The tone shifts from formal to personal, and you can sense the tension building as the foundation of the entire case is carefully placed before the court.
Because my child's father screenshot the phone call, has numerous texts, and my son also overheard Ms. Puerto while he was on the phone with her.
Okay. And so the screenshots show her name as the caller?
It shows her phone number and her name, yes.
Okay. And you're familiar with her phone number?
I don't know if it's changed since, but at the time, yes, I am familiar with her phone number.
Okay. And when contacting Nate, was she trying to pass a message to you through him? Was she just harassing him?
She was harassing him, and I think attempt to, I don't know what her attempt was, to be honest with you. I think she's just angry and decided she wanted to take that route. I can't answer for her.
Okay. And does Ms. Puerto have any reason, to the best of your knowledge, to be contacting Nate outside of the fact that he's connected to you?
Absolutely not. They have absolutely zero connection. They have not talked over the phone in the past or any type of connection to where they should be in contact. And it's unwanted. He was not wanting of her phone calls.
Okay. And when you say she's been calling, is this multiple times a day? Is it once a week?
It happened for about a couple weeks, multiple times a day,
Okay,
to the point where he blocked her.
So 3, 10, 20
I know that I don't know about how many phone calls, but I know that there was paragraphs of messages she was texting him.
Okay. And were those messages about you?
Correct. Yes, they were.
Okay. And do you recall that those messages from Ms. Puerto said?
Things of degrading my character, trying to get CPS involved, doing all kinds of weird accusations of whatever she was trying to do. I don't know. It's been a year and she's been running from this. So.
All right, so are they the kinds of things?
Here's where the situation intensifies. The testimony moves beyond claims and starts leaning into evidence, screenshots, messages, and even a child overhearing conversations. The frequency of contact becomes a key issue, described as overwhelming and intentional. At this point, it's no longer just about whether something happened, but how serious and damaging it might have been, pulling the audience deeper into the unfolding conflict.
That might drive a wedge between you and Nate?
Not only drive a wedge, I'm very concerned about her to begin with because of just knowing that she had a PPO placed against her and her feeling that she didn't care about the law and the PPO and continued to contact further after the PPO was placed, which means no contact. She didn't listen to that.
Okay. And switching gears a little bit, has Ms. Puerto also posted some things on social media or Snapchat?
Correct.
All right. Can you describe those posts?
I was contacted by a couple people, which Snapchat works in a way where it erases, and also if you screenshot it, you can see who posted it. So the people that contacted me told me that they didn't want to screenshot it in fear of her knowing that they did that. So they were pictures or videos of me, which I did not consent of. And her putting clown faces. Obviously, she didn't post my face, I guess. I don't know. Things that are unbeknownst to me because I didn't see them with my own eyes. But knowing Miss Puerto, that she does this to other people, it's not a shock.
Okay. And has Ms. Puerto ever physically threatened you?
No, she just likes to stalk.
Okay. And then do you have any concerns about now that there is no PPO?
Yeah, because I feel that she feels that she can override the law or do what she wants to do, and there's no consequences set. So she feels that as long as you guys are not in the way, then I don't know. She obviously doesn't care about the law. The reason why she got picked up, as I mentioned, on this PPO was because she was trying to break into her child's father's house, and they called the police on her. She has no regard for the law, so I don't think that I feel good. That's why I went to go after a 5-year PPO, and I felt safe with that at the time.
All right. And then has she contacted you since this violation was filed?
No.
Okay.
I would hope not.
Okay. And has she contacted Nate to the best of your knowledge?
He has her blocked, and I think he also changed his number, so no.
Okay. All right. Thank you. I have no further questions, Your Honor.
Very well, Ms. Puerto. Do you have any questions for Ms. Garcia? By way of this would be a cross-examination, so that you have an opportunity to ask questions about her testimony.
I am willing to provide the conversations that were between me and Nate. Actually, Nate was the one who contacted me because he wanted to get further information for his child support case because he's fighting custody with her. She's only allowed to see her child during the weekends, and he wanted pretty much to get dirt on her because he heard of me and her having an argument, and I'm willing to provide.
Your Honor, if Ms. Puerto is going to testify, I would just ask that she be sworn in.
Yeah, Ms. Puerto, I do need to, and this is really your response and testimony, I guess. Do you have any questions for Ms. Garcia?
This part raises the emotional stakes even higher. Allegations expand into social media behavior with claims of public humiliation and indirect attacks. Then comes a turning point, the first direct confrontation. The defendant challenges the petitioner's fear, forcing a raw exchange in open court. What began as structured testimony now feels personal, exposing deeper history and pushing both sides into a more intense spotlight.
Questions, do you have any actual proof of your statements? Because I have never contacted, don't post anything, I don't do anything towards you, ever. I never.
Not recently, no, but I do, and I have sent them. Correct. I have sent them in. And I do have proof of Nate, you reaching out to Nate, and I have proof of my son also making a statement and Nate making a statement against you. Yes, I do.
Okay, well, I have proof of the text messages.
All right, very good. Any further questions, Ms. Puerto?
Do you really honestly feel threatened by a person who was your best friend your whole life and my kids call you aunt?
I'm threatened by a person that
I really don't understand
Okay, hang on.
why
Let's
you're
second.
doing this.
On the threatened question, go ahead, respond, Ms. Garcia, and then I'll hold off, and then Ms. Puerto, you may ask a follow-up if you have one. Go ahead. Are you threatened, Ms. Garcia?
Based on her prior actions of her and breaking into people's houses and her actions, yes, I do.
Okay, Ms. Puerto, any follow-up question?
Yes. if on the paperwork it says that I had been stalking you your whole pregnancy, why did it take 9 months for you if you felt threatened your whole pregnancy? And why did you not show up to court? Because the courts.
Well, let me just take them one question at a time.
Okay,
Why
sorry.
9 month delay, Ms. Garcia?
There was a 9 month delay where she was hiding from the. I'm trying to answer, Your Honor.
Yeah, go ahead, continue. Let her answer.
I have JACO's civil process that has been trying to go after her. It was not 9 months. I already put in the violation of the PPO in May, and it's been taking this long to get to today based on Angie Puerto constantly running. And to answer a question about not showing up, I had mail sent to my mother's house, and I missed the court date because of that at the time. I just literally had a baby, and otherwise I would have definitely been present to the court date.
All
And
right.
I've spoken to you about this prior, Your Honor.
Yes, I recall. Any further, Ms. Puerto?
Yes. Do you have any actual facts on your statement where you continue to say that I break into people's homes? Because that is an incorrect statement.
Well, I have proof that you tried to break into your child's father's home
That's not true.
the night of January 2022. And also based on the fact that the
No.
person that lives there is a probation officer, and she made a statement to the police. I'm sure, and she has a recording of you. I'm sure that they have that also on file. So yes, I can have proof of that.
And Your Honor, we're not here to litigate whether or not Ms. Puerto broke into somebody's home. Ms. Garcia was saying that as an example of why she's actually afraid.
Yes, no, that's what I took it as. So yeah, I think that question probably does not have very much relevance to the matter before the court. Any further questions, Ms. Puerto?
No, I just I have nothing against you.
Very good. All right. Then any follow-up questions, Ms. McNabb?
Ms. Garcia, are there any other contacts or behaviors that you want the court to know about?
What do you mean as far as contacts?
Like from Ms. Puerto?
No, I'm assuming that she knew that this was going on and that it would further incriminate her. I don't think Ms. Puerto's that stupid to do those things, but I feel like when she's feeling like she's getting away with something, obviously, she will evade. I have no further contact with her, nor do I desire that. So.
All right, thank you. No further questions, Your Honor.
Very good. All right, Ms. Puerto, you wish to testify. It looks like. Do you have any additional witnesses or evidence to present, Ms. McNabb?
Not at this time, but I would like to reserve the ability to call witnesses at a later date based on Ms. Puerto's testimony.
Very well. Let me hear from Ms. Puerto. Ms. Puerto, if you'd raise your right hand. Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I swear.
Go ahead, and you may testify to the facts supporting that I shouldn't find you violating the protective order.
Yes. Me and Garcia have been friends for over 14 years. We had an issue with miscommunication, and I really don't know where our friendship went wrong. I have never really threatened her at all. I don't feel that I can get away with anything with the courts. I'm actually really, it's really important for me to stay up with the courts and to keep my name clean. I have 6 kids, and it's really hard for me to stay here and stalk somebody who I have no harsh feelings towards. I also feel that her statement when she says that she thinks that I can get away with things really go towards her, because all the statements that she wrote, the 3-4 different statements that she wrote, were complete lies. I responded to the PPO, and that's exactly how I feel when I did my last response. I feel like she's the one that can feel that she can get away with it because she took the first initiative to get upset with me over something that happened over our friendship, and then call CPS on me, make false allegations towards me, and then the next day I had a PPO order from her. Everything that it's been turned in as far as proof are memes and text messages that don't really make sense. There's no actual prove in any of the forms that she has submitted that actually proves that I have ever came out of my house to stalk somebody. During the time of our friendship, she was the one who showed constantly to my home. I don't really spend time with her at her home. And
But she has 6 kids.
No, let's, Ms. Garcia.
that you supposedly love.
That you
Oh.
leave
That
at
you
You'll have a
home
chance
to come
to,
across.
Ms.
I
McNabb
do
will have
not-
a chance to question.
Don't go there with my kids, please.
You don't care about them.
You
I
may
have
continue,
custody of
Ms.
mine and you
Porto.
don't have yours. I'm sorry, Judge.
Ms. Porto, anything additional?
Yeah, like I said, I have never contacted the father of her kids. He contacted me as soon as he found out that me and her had issues. She had him stored under the devil's cocksucker on my phone. He's the one that texted me, and I'm willing to turn in not just the screenshot, but the actual phone records with every single conversation that has been made. I would never contact her child, whom I actually love and my kids love. And I feel really sad, really disappointed, because this is a person whom I actually really cared about. I have always protected her. I have never been physically or anything towards her. Yes, I did get upset about situations during our friendship, and I was always honest with her, but I have never actually threatened her or anything. And I really don't, I'm still to this day clueless and not understanding where she comes up with writing all these false allegations on these statements. I mean, you wrote 2-3 statements, and when the day came to see me in person, it had gotten adjourned, and then it came back, and then you claimed that you didn't get the information.
Objection, Your Honor. The witness is addressing the petitioner.
Yeah,
rather than the court.
that's not in the form of this isn't a question.
I
This
know.
is your
I
testimony.
just feel confused because this case has gotten dismissed already, and we're pretty much going back. And I just want you guys to know, I don't have time nor to put my freedom at risk away from my children. I'm a permanent resident of this country, and I have never, ever threatened Lisette. I don't have any harsh feelings towards her or her child, and I'm willing to prove anything that's said against me with actual proof. And I'm actually very hurt about the situation, and I don't have time to be posting anything about Lisette. Just like how she said, I also receive images and videos on Snapchat and Facebook as well of her talking down on me and contacting third parties. I actually have text messages of her texting my friends trying to tell Angie to delete our pictures on Facebook, tell Angie this, tell Angie that. And this was during the PPO. And I find it really disrespectful that if I make one bad move, then it's everything, it goes down on me. But she constantly is calling the father of my kids, trying to take him out to lunch, and called him, and actually she actually told him I was the one who called CPS on your baby mama.
Your Honor, I would object. The PPO is against Ms. Puerto, not against Ms. Garcia.
Yeah, and further, that would be a hearsay testimony. I think we're getting a little bit of fire from the alleged violations.
I apologize. This was really impacting in my life. I work really hard every day on my life to change my background, my past, and move up forward. And I wish the best for her and her child. And there was nothing more that I wanted anyways before me and her.
Ms. Porto, I think that I arraigned you after you had been arrested on the bench warrant because of a failure to appear and a misunderstanding. Correct. Because of the termination. Yes. How much time did you already spend in jail on that?
I ended up going to jail for 2 days.
Okay. All right. Thank you. Ms. McNabb, any cross-examination for Ms. Puerto?
No, Your Honor. However, I would ask if the text messages become an issue. I would ask for an adjournment to review those, as I did not receive any text messages from Ms. Puerto to review.
No, and I don't have any of those in the file either, but I think we can proceed without those at this time, unless either party thinks they're absolutely necessary to my determination.
You have my word, Your Honor, that that's not the road I would want to go down at all.
Okay. Well, if you want those, Ms. McNabb, I can order them, and then we can.
I can also submit them if that's what you need. Yes.
I would just like to recall Ms. Garcia as a rebuttal witness.
Very well, Ms. Garcia, you're already under oath. You may proceed, Ms. McNabb.
All right, Ms. Garcia, can you unmute yourself? Oh, wait, let me ask a question
Can I
first.
have Nate as a witness for this trial? Can I have him come in as a witness as himself?
Now we reach the most dramatic stretch. The defendant pushes back hard, denying everything and flipping the narrative by claiming the other side initiated contact. Emotions rise as past friendship, personal struggles, and family responsibilities come into play. Interruptions and objections create chaos, and just when clarity seems possible, a key witness is missing. The judge adjourns, leaving everything unresolved, and that uncertainty is what lingers most. Don't forget to like the video, subscribe to the channel, and we'll see you in the next video.